So, ladies and gentlemen, and especially the chief trainer, I just came to know that I can call him by a very short name, Mr. Inva. The trainer, Mr. Sarma, Ms. Majid, and the trainees and the trainers of Bangladesh International Mediation Society. I think it's a proud privilege on my part to be here this morning and say a few words and share some of my experiences on alternative dispute resolution and mediation as such. That I'll delve differently. But as I was just thinking of coming to this gathering and thinking what to say at the inauguration, so I was just going through the brochures that were published by BIMS last year and this year, and I found quite, relevant information in the brochure. And Mr. Goswami, he collected this information from the Supreme Court sources, which says the number of cases which are now there, the backlog of cases, not only in the Supreme Court of the country, but also in the subordinate courts. And he has also identified some of the reasons that why this backlogging of cases is there in our administration of justice system. And when you go, and without looking into the causes of this delay in justice delivery, probably you'd all agree with me that even if there is a hindrance to access to justice, that is a denial of human rights. If there is a hindrance to access to justice, that is a denial of human dignity. And if human dignity is the essence of human rights, then we know that this country, the People's Republic of Bangladesh, this emerged because of our aspirations to build a society that would be based on human rights. Let us recall, the lofty ideals which are proclaimed in our Proclamation of Independence on 10th of April 1971. And in that, I would say, so immensely important document of our national history, why did we go for the liberation war, and which today we can consider to be the values of a liberation war, the values of a republic. The document says that in order to ensure for the people of Bangladesh, and I want to repeat it, in order to ensure for the people of Bangladesh equality, social justice, and human dignity. Very core values: equality, social justice, and human dignity. And if you see, if you go for the establishment of the rule of law and access to justice of all in the country, then in some way or other, all the three values are related there. Therefore, justice seeking and justice delivery is of cardinal importance in civilization. Someone said, and as I just mentioned, not someone, but Professor Madhava Menon, he said in one of his speeches just a few months back at the University of Chittagong in Bangladesh, that one of the greatest blessings of human civilization is the innovation of the conception of rule of law. I'm pretty sure my former student and judge, you'll agree with me that one of the greatest blessings of human civilization is this innovation of the conception of the rule of law. Whenever there is hindrance in justice delivery system, that is deviation from the rule of law. Therefore, justice is something that we aspire for. Justice is something that must be attained whatever the cost is. But if the formal way of delivery of justice is hindered, if formal way of delivery of justice becomes impossible because of so many other extra legal factors. There are legal factors and all around this room, I'm pretty sure that the legal hindrances towards the delivery of justice. But there are extra legal considerations as well. And in our society, the extra legal considerations sometimes weigh much more than the legal considerations. Then what is the way out? The way out is to find out some alternative to the regular way of administration of justice and delivery of justice. And this one of the ways out of this regular way of delivery of justice is mediation, which is merely one of the forms of alternative dispute resolution. So what I'll do is, it's not going to be formal opening like that. Well, I hereby declare the training session open. So I'm not going to make that kind of, pronouncement or declaration. But what I'll do, since I'm a teacher, so what I'll go is probably share some of my thoughts with you as the introductory remarks to this training session. I hope that it will be of some help, though this would be something like, very elementary and rudimentary for people to my left and to my right, because they are the experts in the field, and sometimes they might be laughing at me that, come on, Professor, you are talking about something that anyone should know in this field of arbitration and mediation. But nonetheless, even if we know everything of it, always remember that repetition is not always bad. Sometimes repetition is even necessary in order to master the information that we have. So it is only with this humble intention I would now probably switch over to my presentation and have a kind of interaction with all of you on alternative dispute resolution. Is that fine with you?
Sure.
ADR, we know that it's for alternative dispute resolution, right? But at times it appears to me that should we call it ODR? Can anyone of you tell me what this O would stand for? Anyone? Can you guess what this O would stand for? Anyone? Can you give it a try? Opportunity dispute resolution?
Yeah.
Opportunity dispute resolution, it doesn't really sound nice. Anything else?
Like outdoor dispute
Outdoor dispute resolution, maybe.
Okay.
Anything else?
Ordinary.
Ordinary dispute. Oh, ordinary is too ordinary. See? Anything else? Open dispute resolution. Well, what I meant for O is whether we should call it the only dispute resolution, the only way of resolution, so that যে কথাগুলো আমাদের ট্রেনার সবসময় আমাদের বলবে যে we are interested in a win-win situation. You see? So that it's not a win-lose situation, so that we end up with a win-win situation. So whether we could call it the only dispute resolution, there's something for you to consider at the end of the training session, that whether ADR should be considered as the only way that we should focus on for purposes of dispute resolution in our society. Next question that we'll address is it new? Well, Inva has just come from England. Mr. Sarma is coming from India. And from Delhi, they're all coming. Is it a new idea? A new idea they're sharing with us, that they're propagating. And therefore, we should consider the pros and cons, and then probably align with this idea of alternative dispute resolution. We'll see to that. And why is this alternative necessary? Is it appropriate? And finally, is it complementary to the usual the dispute resolution mechanism that we have in our society? Now, is it new? Let me tell you very frankly, it is nothing new.
Yes.
It is nothing new. Inva knows it very well, that the Indian subcontinental tradition and history, alternative dispute resolution had always been inbuilt in the social mechanism. It is the British who probably, taught us a different way. And the British not only divided and ruled us, but also divided our conscience, the world of thinking pattern. That is also distorted by the British colonizers. And we are paying for that. Had we had the traditional ways of resolution of disputes, I think the peace and harmony in the society would have been much more greatly served and preserved than it is today through the state delivery mechanism of justice. Now, this is one from, let me tell you, the 14th century England. I'm giving an example, and this is one of the mediations, So the parties have gone to the court. Now, in the court, look what is happening in the court. The counsel, so the lawyer says, tell me, wasn't the turkey for the defendant? টার্কি ওই যে বড় মুরগি আর কি, যেমন আমেরিকানরা থ্যাঙ্কস গিভিং এ ব্যবহার করে, আমাদের বাংলায় কি বলে এই টার্কিকে? বাংলায় কি বলে? টার্কি বলে। সো ইটস yeah, well it's delicious. So tell me, wasn't the turkey for the defendant? And the defendant, no answer, just kept stunned. No answer, just counsel, tell my lord the truth. Now, wasn't the turkey for the defendant? Now the Chief Justice, he's retorting, what on earth has a turkey to do with this case? মামলা নিয়ে কথা বলছে, এখানে এবার এই টার্কির কথা আসলো কেন? কি শুরু করেছো তোমরা এটা মানে কোর্টের ভিতরে? কাউন্সিল বলছে, দেখেন লয়ার বলছে, it is a form of local arbitration, my lord. And local form, what was the local form? Say for example, he is the plaintiff and he is the respondent. So what was the form of arbitration? So you put grains here on the left hand side and put grains on the right hand side, and then you bring a turkey and put it in the middle. Now which grain the turkey eats first? কোনটা ঠোকর দিয়ে প্রথমে মুখে নেবে, যে গমটা প্রথমে মুখে নেবে সে জিতে যাবে, he wins. That's it. It's just like tossing a coin, whoever wins, head or tail. So that was the local form of arbitration. But you see, what was the importance attached to arbitration? এরপরে দেখেন what the Chief Justice says. দেখেন উনি বলছেন, do you mean to tell me that the plaintiff has brought this case in disregard of the award of an arbitration? আরবিট্রেশনের যে সিদ্ধান্ত হয়েছিল সেটাকে অবজ্ঞা করে, অমান্য করে সে আমার এই কোর্টে এসেছে আবার মামলা করতে। কাউন্সিল বলছে, দ্যাট ইজ সো মাই লর্ড, ইয়েস। তখন চিফ জাস্টিস বলছে, ডিসগ্রেসফুল। কি অসভ্যতা, কি অ্যাপিল ডিসমিসড উইথ কস্ট হিয়ার এন্ড বিলো। তারপরে লয়ার কি বলছে, কাউন্সিল বলছে, দ্য লর্ড চিফ জাস্টিস অ্যাফার্মস দ্য টার্কি। So you see, ultimately, not the turkey, but affirms the mode of arbitration. So this merely tells us that what kind of importance arbitration had and had been in cultures in different societies with different peoples. And therefore, this is something which is not new. Obviously, we are probably not thinking about this kind of arbitration, this kind of, no, we are not in favor of that. Probably the civilization has progressed much from that level of consciousness, and we are in a stage when we can devise better forms of arbitration so that justice is truly delivered. Now, why this alternative is necessary? So you see, I've just given some points of thought and trying to draw a parallel between litigation and ADR. And ADR, again, I'm telling you that ADR may be of divergent forms. Number one is, litigation is always adversarial. So one party against another, and one party prevails. Whereas ADR is non-adversarial. All come out together to work out an answer. দশে মিলে করি কাজ, হারি জিতি নাহি লাজ. That's the message. Let's all be together. Because you see, social problems, social relations are such that there cannot be total winners and total losers. You can never have. But in a litigation, there are total winners and total losers. So that is something that we need to ponder. Number two, argue. Points of law and points of facts are good against one another. Points of disagreement are focused. Only those with a standing may participate. So if you don't have the so-called locus standi, right? Yes. Then the judge, you tell, hey, why are you wasting my time? Just get lost. Don't waste the precious time of the court. Now, whether I have a standing or not is something which matters very important, very significantly in a litigation. Whereas in ADR, everyone talks. Events are related from each point of view. No parties, non-parties, I'm sorry, non-parties may also speak. Because we're in a society, we're in a community, we're in a group, we're in a neighborhood. So we're not in, in watertight compartments that we don't see each other, we don't relate to each other, and we don't have any connections and relations with others. Rights of individuals, paramount. Much care is taken to protect individual rights. This had always been the case with Western jurisprudence. The Western jurisprudence is very much individual oriented. It's I, my. And nowhere, we is very, very, in very small letters, we. It's always I in big cap letters. It's mine. Much can see into individual. They can have rights of community. That is paramount. The right of the society is paramount. The right of the state is paramount. Emphasis on the community rather than on the self or individual. So you see, the focus, the philosophy is totally different from regular litigation, compared to ADR. 4. Vindication of society. In criminal matters, emphasis is on vindicating the matter for society. Emphasis on victim or reintegrating the accused. That is what, as lawyers or judges, you're all well acquainted with this philosophy. Whereas in ADR, it is not vindication, but it is restoration of peace. Again, going back to the days of Confucius, social harmony. The social harmony must not be breached, whatever, comes. So, the social harmony is of paramount importance, and therefore restoration of peace is the target. In a community and resolution of underlying problems, that is the goal of ADR justice. In litigation, the consequence is punishment. We think of punishment, we think of imprisonment. Well, you like it or not, that is what it leads to. Whereas in ADR, it may be forgiveness, it may be reintegration, no imprisonment, but there may be banishment, shame, ridicule. These are the things that we disperse, we don't really care for, we don't really encourage in our societal relationship. Therefore, we abhor these negative consequences of this type of interpersonal relationship in the society. Rights of accused, right to remain silent, that we know. যে আমাদের উকিল সাহেব বলবে যায় তোমার কোনো কথা বলারই দরকার নেই, চুপচাপ তুমি দাঁড়িয়ে থাকবা, বাকি কাজটা আমি তোমার করে দিচ্ছি. Right to remain silent, ability to deny accusation with burden of proof to be borne by accusers. Whereas the obligation of the accused, obliged to speak. তুমি চুপ করে থাকলে তো কিছু হবে না, তোমার মনটাকে খুলে দাও, সব কথাগুলো বলো, এবং সব কথাগুলো বলতে বলতে তোমার যা অভিযোগ বা তুমি কেন তোমাকে অভিযুক্ত করা হয়েছে, তোমার যা কিছু তোমার পক্ষে বলবার আছে, you come up with all kinds of arguments and everything that you want to share. Honesty in all parties seeking truth. All speak through rendition of facts. The evidence speaks for itself, no burden or reversal of burden. I'm pretty sure that when you go into, doing the practical exercises on mediation, Inva will tell you that Mr. Pal has said so, so don't ask him that praman karen eta dekhi ki hoyeche. No, that's not the way that mediation is conducted. Mediation, the technique of mediation is totally on a different level. The technique is totally different from other kinds of dispute resolution mechanism that we know. Fine to state separation of church and state. This is, church and state are different. There's nothing, obviously, you might ask me various questions that how can the church and the state be different when the state religion is Islam? But those are jurisprudential questions, we're not dealing with that. But apparently in a civilized society, in a democratic society, in a modern society, the church and state are segregated or separated. Law is secular matter. Though, আমরা বলছি যে state religion Islam, but then again we say that law is secular. Law is separate from religion. Whereas in India, restitution of victim harmed. Law is part of whole. Spiritual matters are not separated out from the secular. We take everything as a whole. Nothing segmented, separated from each other. So if religion, if tradition, if customs, if they have a role to play in mitigating the grievances in the social particular group, why not take those also into consideration? That is the beauty of ADR, that is the beauty of mitigation. Now in litigation, English language. My student had been fighting that why English language? To the detriment of the poor litigators, right? To the poor man of this country who doesn't understand English, and then you're pronouncing your verdict in English, and they understand nothing, and the lawyers seem to be very happy. Well, it's me only who understands, and it's good that they don't understand. So you see, but here, many words cannot be translated into native language because there is no equivalent thought. You see, in science, there is a concept which is known as geography of thought. I mean, it's a geography of thought, how we think. So the process of thinking is also something which varies from people to people, from nation to nation, from clan to clan, from tribe to tribe. And that is not taken into consideration when you are following only English language, and that is the language of the court. Whereas in ADR, you can have the recourse to native language. Language carries our world view. Words cannot be translated to English because there is no equivalent thought. You need words. You don't need English. We want to understand each other. We want to have this rapport with each other. We want to communicate effectively with each other. And this is what is necessary, effective communication. And that happens when I can speak my language, when I can open up my heart. अगर मैं हिंदी से बात करूं तो मेरी तो आवाज तो नहीं सुन पाएगी आप. अच्छे नहीं ना, ठीक है ना, तो इसी तो है. Emphasis is on written record. Law is written and must constantly be updated. So we believe. The judge, the lawyer appears and the judge, দেখান দেখি কোথায় আছে, আইনের কোথায় আছে, show me. স্যার এই নজিরটা এত সালের, এত প্রিসেন্ট, দেখান দেখি কোথায় আছে, রিপোর্টেড নাকি, কোথায় রিপোর্টেড দেখি আমাকে দেখান কোথায় লেখা আছে কথাটা. It has to be written, and that is what carries the value in the court of law. Whereas in ADR it's oral. Words are alive. Law custom is passed orally. So everything is oral. It's traditional. It's from generation to generation. It's carried over and practiced. And that is what makes it a living law in the society. Separate judicial body and right to appeal. Because you have the structure of the courts. So from one instance to the other. So we know, and the lawyers know that. Knowing fully well that the case is, it doesn't have that much of merit to go for appeal, but then the lawyer would say, কি বলেন আপনি? এই জাস্ট কিছু বোঝে না. So higher court দেখেন না, higher court will get justice. Lawyer knowing fully well that even in the higher court he's not going to get the relief, but at least his pocket is going to be a bit thicker. This is what may not happen in ADR, because that is not the purpose. Justice is of paramount importance. Justice is the goal. Therefore, traditional customary leaders participate. No right to appeal. Final resolution of the matter is sought. This is what. If the resolution persists, if the conflict still persists, if there is no resolution, if there is no finality to the problem, then what's the use of these exercises? What's the use of bringing these people? They'll come from far and few between, and they'll see, they'll mediate, they'll resolve, and then at the end of the I'm money that. Then what happens? Then everything is a nullity. And if everything is a nullity, then it's merely your wastage of time and resources. No, that cannot happen. So you must come with open hands and open mind. So these are the different forms of ADR. As I mentioned, that there are different forms, negotiation. I talk with Inva. We have a problem, you see, because Inva, he has occupied the room in the hotel which I was supposed to be allocated. I come and say that Inva has occupied. No, Inva, come on, you have taken this room with the view. to Hathir Jheel. I wanted that room, I wanted that room, I wanted to open the window and see the Hathir Jheel, the beauty, and the water. And now you have occupied. No, I'm not going to live that. You have to change the room. So we have a dispute. Now, how to? We are not going to call Mr. Goswami. Mr. Goswami, you have a problem. So you please come and resolve it. No, I'm not going to the court of law. So what do? We negotiate. Come on, let's sit together. Let's sit. And then as we directly, face to face, we talk to each other, trying to resolve the matter. This is what is negotiation. But remember one thing, that sometimes negotiations might take place without even facing each other. And I'm just just for fun maybe, but that is historical fact. When the North Vietnam and South Vietnam, when Vietnam was not unified before the war, during the war. So North and South Vietnam, they were negotiating. As they're negotiating peace, they hated each other so much. Just like Khalid Hasina, they hated each other so much. They didn't want to sit face to face. So what they did, so North Vietnamese came and in the room, they sat like this, facing the wall. South Vietnamese came and they sat like this, facing the wall. So both were just looking at the wall and talking to each other. That did take place. So you say negotiations can take place even without facing each other. You're just facing your back. But then once you start talking, opening up, then the, as we say, that the the ice starts melting. So once it starts melting, then the normal, usually, at the end of the day, you find that everything is resolved. And I say, Inva says, come on, Mizanur, come and have, you can stay till 12 midnight and watch the beauty of Hathir Jheel, no problem with that. And we can have a drink together, and have chat. Fine. I'm also happy, he's also happy, no problem, and the dispute is resolved. That is negotiation. But then there is mediation. Well, in mediation, obviously, mediation always involves a third party. I'm not going to detail out anything because I think you'll be talking about all this throughout the day, today and tomorrow, so I'll not waste your time. But mediation, it involves a third party. But the third party is a neutral third party. That is very important. It's a neutral third party who does not impose his or her wish or instructions to either of the parties. That is crucial for being a successful mediator. Total impartiality, total neutrality, that is the eligibility of being a mediator. Then you have arbitration. Well, arbitration, we sometimes call it its ad hoc court, Arbitration is ad hoc court. Yes, it's speedy. It is less expensive compared to litigation. But then again, in arbitration, it's not win-win. Arbitration is also win-lose. Although we have very many positive sides of arbitration, but at the end of the day, arbitration ends up like a litigation. Total winners and total losers. There is med-arb, sometimes you need to initially go for mediation, and if mediation fails, then arbitration. So there may be some mechanism in some jurisdictions. I'm not detailing out those right now. So that can be another form of ADR. There is mini trial, very informal. So mini trial they call it. So not the kind of, the evidence act to be followed in toto, but some of the exceptions done so that you can have a very speedy but small trial. Not all the the witnesses being called and examined and so on and so forth. And there are certain court attached procedures also. The court directs, even multi-door court approaches are also there. You might be, directed from one court to the other in order to have the final resolution of the problem, but which would be an appropriate solution for the problem at hand. Now about mediation a bit. What is mediation? The question is that, even if we don't discuss it right now, I'm pretty sure that the trainers throughout the day and tomorrow, they will come back to this question. What is mediation? Is it always voluntary? Can the parties be forced to agree to a settlement? What do you think? initial responses. Can the parties be forced to agree to a settlement?
No, answer is no.
The answer is
No.
No, yes, no. You know, does the mediator work with parties together or separately?
Together.
Well, it's both, you know.
Yes.
It's both. At times, yes, most of the time it would be together.
Together.
But when the need arises, then the mediator can also
Separately.
sit with one of the parties separately.
Separately.
You know, you check some of the
Situation
things,
is with
some of
that.
the problems, you know, elucidate those, and then again come back to the forum and they
Together.
again sit with both the parties.
Both the parties.
So it's the different kinds of tactics that you have to, you know, apply.
By the mediator.
Should the reached agreement be written down? What do you think?
At least in
Subcontinent, it has to be yes. Yes, you know, it has to be written down. Because once you have reached, so that evidence has to be preserved.
Preserved.
That you don't go against your own decision. At the end of the day,
reference.
you don't change, you know, your policy. You don't change your mind. No. Once you've come in, and all the peoples have been involved in the process, so you cannot simply change your mind, you know, the moment you want. No. You know, what types of disputes can be settled in mediation? Generally, you know, others can be, you know, very big commercial disputes, I'm pretty sure, that are the, you know, and today lawyers are interested in mediation because of this, you know, huge number of commercial disputes that come out for, you know, mediation. Because, you know, if you go for litigation, then if your $1 million, you know, they do not circulate, if in one day of lazy $1 million, one lazy day, is a loss to the economy, is a loss to the owners, is a loss to the, you know, the factory owners and others. So the more you roll the capital, the more income you derive out of it. Therefore, you need a speedy resolution. Therefore, commercial disputes are the, you know, the top echelon of the mediation disputes that we know today. But, you know, family disputes, landlord, tenancy, business and trade, employer-employee, environmental disputes, all these may come, you know, as a matter of fact for mediation purposes. Now, these are some of the good qualities, you know, that a mediator should possess. Some of the good qualities, you know, one needs to be a very good listener. Now, you can have even a training on listening, that how do you listen, you know, and listening has so many different types of listening, you know. There is active listening, there is passive listening, there is receptive listening, you know, and so, you know, which particular type of listening you need to apply, that will depend on a concrete situation. But the mediator has to know the parties, you know, the disputing parties, so that knowing their nature and characteristics, the mediator can judge and decide which particular form of listening needs to be applied in a particular situation. Obviously, he or she needs to be totally impartial, help parties communicate with each other, you see. Help parties communicate with each other, encourage cooperation and understanding, helps find solutions, and not the least, keeps confidentiality. Very important. Keeps confidentiality. এখানে আলাপ হয়েছে ফ্যামিলি ডিসপিউটে বাইরে গিয়ে আরে সব জানেন আপনি আরে ভাবতাম এটা ভালো ভাবতাম ফ্যামিলিটা তো সুখের এর ভিতরে এত গরম তো বুঝতে আমি জানি কি হয়েছে আরে ইউ ক্যানট that cannot be something that you discuss and enjoy and share with others, because this confidentiality, this is a keystone, this is, I think, a thumb rule for any kind of ADR that you are involved in. So these are the things that needs to be done, obviously. Now you see, in any mediation, these are the keys to mediation success. That one has to distinguish between interest and position. Party has an interest as well as party has a position. So now we'll look into that, but create options to satisfy everyone's interest. This is what is important. Not the position. You know, he has an interest to stay in the room that he has occupied. I have also an interest in that particular room. But I have a position, he has also a position. How do you distinguish between interest and position is very important. Let's see that through an exercise. I've invited my students to you know, play a simulation. So we'll have this very small simulation, and then we'll see that how you will be able to distinguish between interest and position. Please, would you please come over here yourself? Sisters, okay? They're two sisters and he's their brother. Right. Right, okay. Okay.
আরে কমলা বাহ আজকে আমার ফ্রেন্ডসরা আসবে আমি তাহলে ওদেরকে আজকে কমলার পুডিং বানিয়ে খাওয়াবো যাই তাড়াতাড়ি বানিয়ে পুরো আসবে
এখানে একটা কমলা ছিল না এই কমলা নিয়ে কোথায় যাচ্ছিস
আমি কমলা নিয়ে পুডিং বানাতে যাচ্ছি
না না আমার কমলাটা লাগবে আমি ডক্টর দেখালাম সেদিন ডক্টর দেখালাম মনে নেই ডক্টর বললো আমার স্কিনের সমস্যা আছে এর জন্য
তো আমি একটাই কমলা আছে একটু আমার ফ্রেন্ডরা 20 মিনিট লাগাতে হবে আমি আগে দেখেছি
কিন্তু এটা একটা মেডিকেল ইমার্জেন্সি
আর পরে ডক্টর বলে
কি হয়েছে চিল্লাচিল্লি কেন হচ্ছে
আমি কমলা নিয়েছি বলে আপু
আমারও কমলাটা লাগবে তো
কিন্তু আমি আগে দেখেছি তো
দাঁড়া কমলা আগে কে দেখেছিস তুই
আমি
আচ্ছা তাহলে আজকে কমলা তো
থ্যাংক ইউ
Right. So this is first episode. So they have a dispute, and the orange is giving to this sister because she has found the orange first. You know, so she has a better title to the orange. You know, let's talk it in this the first chapter. Okay. Now, the second episode. Okay. Now the second episode.
আরে আজকে কমলা আছে ভালোই হয়েছে আমার আজকে ফ্রেন্ডসরা আসবে ও কোনো 20 মিনিট আছে মাত্র আমি তাড়াতাড়ি গিয়ে বানাই
তুই কমলাটা আজকেও নিয়ে যাচ্ছিস
আপু দেখো আমার ফ্রেন্ডরা 20 মিনিটের মধ্যে আসবে
প্রত্যেকদিন আসতে
আপু
থাকে
আমার মাত্র আজকেই আসবে পুরো বছরের মধ্যে মাত্র একটা দিন আমার ফ্রেন্ডরা আসে আপু প্লিজ
আজকে আবার চিল্লাচিল্লি কেন কি সমস্যা কি তোদের
আমি পুডিং বানাবো কমলা নিয়ে আপু
আজকে এই কমলা নিয়ে সমস্যা
ডক্টর বলেছে
আপু ভাইয়া দেখো এটা কি হচ্ছে
আজকে আমি একটা সলিউশন দিচ্ছি তোদের এই যে এই হাফ তোর এই হাফ তোর ঠিক আছে তো
Okay, fine. So that's the end of the second episode, okay? So the orange is now divided into two equal halves, and both the disputing parties are given the equal share of the orange. And they seem to have resolved the dispute. Now let's have another situation, okay?
আরে কমলা আজকে শেষ দিন আমার ফ্রেন্ডসরা আসবে আজকে ওদেরকে খুব মজার একটা পুডিং বানায় খাওয়াবো চাই তাড়াতাড়ি বানাই
তুই সবচেয়ে প্রতিদিন কেন কমলা নিয়ে যাস তুই জানিস যে আমার জন্য এটা কত ইম্পর্টেন্ট
আপু দেখো আজকে শেষ দিন ওরা আসবে
বোনের চেয়ে
না
ফ্রেন্ড
আপু দেখো তুমি প্লিজ আমাকে ইমোশনাল ব্ল্যাকমেল করো না তুমি অবভিয়াসলি আমার কাছে ইম্পর্টেন্ট আমি আজ নিয়ে আসবো তো কমলা একটাই আছে প্লিজ আপু
আমার স্কিনের
আমি
আজকেও কমলা নিয়ে সমস্যা কি সমস্যা কি হয়েছে
আমি কমলাটা নিচে প্রত্যেকদিন আপু আমার সাথে এখন ঝামেলা করে
আমার কমলাটা লাগবে
আমি আগে দেখছি
আচ্ছা দেখি কমলা আমার হাতে আচ্ছা কমলা তোর কেন লাগবে
আমি পুডিং বানাবো
তোর কেন লাগবে আচ্ছা তাহলে তোর কোন অংশটুকু লাগবে কমলা
ভিতরের অংশটা
তোর শুধু খোসাটুকু বলেই হবে
হ্যাঁ,
আচ্ছা ঠিক আছে আজকে আমি একটা ব্যবস্থা করে দিচ্ছি এই যে পুডিং এর জন্য ভেতরের অংশ আর তোর জন্য কমলার খোসা ঠিক আছে খুশি দুজনেই
থ্যাংক ইউ
Yeah, thank you. আচ্ছা দেখেন এখন এই লাস্ট এপিসোডে এসে what do you find? We find that both of them are quarreling over the orange, but when the brother intervenes, he finds that one of the sisters need only the flesh of the orange for the pudding that she is going to prepare, whereas the other sister needs only the skin of the orange in order to put on her skin, like Majid, right? So you see, now once the interest has been identified, so according to the interest, the matter is resolved. Now just think over. You know, in the first situation, the whole orange was given to someone because of certain ground. You know, whether this is logical or illogical or reasonable or unreasonable, that's not the question. But one becomes the total winner and the other total loser. So, do you think that she's happy when the orange is totally given to her?
No.
She's kind of, I don't. Okay, is she পছন্দ করে?
waiting for a chance to revenge
Absolutely. সময় আমারও আসবে। এক মাগে শীত যায় না। দেখবো এখন। In the next episode, you see, it is divided into two equal halves. So, you see, two equal halves, but there is colossal wastage. Because one would be wasting the whole flesh of it, the inner part of the orange, because she doesn't need that. She only needs the skin in order to, sort of beautify her skin. And she'll be throwing out into the basket, probably, the orange, which she doesn't need. Whereas the other one would be only half the, the flesh that she is in need of. Therefore, again, that cannot be an optimum, that cannot be a solution which satisfies. Time being, they may be satisfied, but it's not an optimum satisfaction. It's not an optimum way of resolution of the dispute, the interest of all. Whereas in the third variant, what do we find? This interest and position. So now the brother has identified the interest and the position. The position is very clear. I want it to prepare the pudding. I want it to beautify my skin. But the interest is, for a specific purpose I need only this. So once you come to know the interest, fine. It happens in family matters, it happens in everyday life, and it might happen even in international politics. Think of the 1968 peace accord. Israel and Egypt. 1978, at the Camp David peace accord between Egypt and Israel. What happened? Egypt says that you have to hand over, return the whole of Sinai that you have occupied in 1967 war. And Israel says, no, I'm not going to return that. So the position was, I want my territory back because I have the sovereignty over my territory. And Israel says, I will not return Sinai because I have occupied it. Now after, a while, Jimmy Carter, so he looks into the interest of the parties. What is your interest, Mr. Sadat, President Anwar Sadat? Well, I want that because this is my territory, this is my dignity, it's my honor. The whole of Sinai has been occupied by Israel. How can it be so? So I want my territory back. Okay, and Israel, what do you reckon? What is your interest in that? Why are you occupying that? Well, I don't need this Sinai as a land. I don't need this territory, but I want it so that no military operations can be conducted from Sinai. So from security perspective, I want it to be demilitarized. Fine. So now that we know the interest, now Anwar Sadat says, fine, we will have no military operations and no weapons, nothing, no military exercises in Sinai. And Israel says, in that case, fine. If that is the agreement, then I am going to hand you over Sinai. And that's how Camp David peace accord was signed. So you see, once you identify the interest of the parties, it becomes easier to resolve the dispute. Even such internationally volatile, very complicated issues may be resolved through mediation. And Jimmy Carter played the role of the mediator. And he's one of the best mediators that we have. So you see, now, thank you. All these three, they are students from the University of Dhaka, Department of Law. So please give them a... Right, now you see, so now insist on using objective criteria. You have to be objective. On what basis you're really, identifying your interest and so on, and understand the alternative to agreement. Well, if we fail in mediation, if we fail to reach an agreement, what is the alternative? Is the alternative a better one? That is something that will probably convince the parties to reach an agreement. Fine, we are failing to reach an agreement now. You don't agree. So what is the alternative? What is the best possible solution, the alternative that you have? Again, going back to the court, how many years? How much money you have to spend? And then what do you do in the interim period? So you see, once you come to know the situation, the alternatives, and the alternatives are not something better than you have through mediation. Therefore, that will help you to reach an agreement. Now, what is the role of the lawyer in mediation? I think, the trainers will tell you more in details, but simply some points of thought, that what is because, many times when I sort of introduce the continuing legal education program in the Bangladesh Bar Council, which is to be known as the CLEP program, which subsequently developed in the Bar Vocational program, the Bar Vocational course, then I thought that in ADR, the lawyers initially had a natural tendency to resist. No, what is it? This is not for the lawyers. because lawyers saying that if ADR is popularized, probably it will have a negative impact on their earning. Less clients will be there and they'll be earning less. It will be challenge to the profession. So initially there was a negative attitude from the part of the lawyers, but which proved to be not valid. It's not the case. The lawyers, they will have enough of the litigations to live their life, as well as they will have another additional role to play, the role of a mediator. Why? Because for resolution of these disputes which have a legal connotation, you need knowledge and expertise. It's not common knowledge, but you need legal knowledge also. You need some expertise, and that the lawyers have. So you will always be in demand, even when you go for ADR. It is not common sense, but legal sense that is necessary, and that you have. Not all cases are not always ADR. This is something also to be remembered. Then why not? Because not all the cases can be, resolved through mediation, through ADR. So there will be cases always which will have to be sort of resorted to the court of law, to the regular way of resolution of disputes, because not everything and anything is possible to be resolved through ADR and through mediation. So therefore, these, the lawyers do not have anything to be suspicious of, anything to have any resentment against ADR, because ADR is going to probably add to your expertise, your knowledge, add to your acumen, and add to your status in the society. Because once you are a very, I think, sophisticated mediator, then through mediation also, I think you can earn enough. And at times that can be even more than you earn as a mere practicing lawyer in the course of law. So I think this is a mere, very humble introduction to the course that we have. I know that this is nothing special knowledge that I communicated to you, but I think this is nonetheless a beginning of the training program that you are having, and I wish you all the success in the next 2 days of your interaction with the very learned trainers who have come and joined us from abroad. And thank you very much for giving me this opportunity, Mr. Goswami. Thank you very much for inviting me, and it had been my pleasure to be here with you this morning. Thank you.